Everyone, I'm Judge Jackie Powell. This is First Appearance Court. Today I will let you know if I've determined probable cause based on the police reports that I read this morning. And after that determination, we will be able to talk about release conditions. I encourage everyone this morning not to talk about your case on the record. Today is not your trial date, it's not a hearing date, and anything you say in this courtroom is being recorded and can be used against you at a later time. If you are represented by counsel, I encourage you then to speak with your attorneys before saying anything on the record. For those of you represented by the Public Defender's Office, I do have an attorney here in the courtroom with me, as well as there's an attorney over at the main jail. For those of you at the other facilities, you are able to speak with those attorneys via phone. For those of you represented by private counsel, they usually come to the courtroom and they will be able to address your case from here in the courtroom. You'll be able to see them on screen. I also need to let you know that in the courtroom, I also have the attorney from the state attorney's office. I have a representative from confinement status and a representative from pretrial supervision. And those persons are able to provide any other pertinent information that I may need to make a decision this morning, as well as we have the clerk of courts to maintain the records. Okay? So I will, a few of you, not a lot of you, some of those of you with misdemeanor cases, and maybe if those misdemeanor matters are not attached to any other felony matters, you may be able to resolve those misdemeanor cases today, and if applicable, I will accept the plea. But just note that if it's a violation of probation, if it is a felony matter, those things I have no control over in first appearance. From here today, your case will be assigned to a division judge, and moving forward, all hearings, if you go to trial, those things will be heard before that division judge, okay? All right, so there are a few persons that the jail, the jail has asked me to call out of turn, and so what pages? Oh, they were waiting on someone. Wasn't Perry Lethbridge, were you waiting for someone?
No, we can proceed with Mr. Lethbridge, Your Honor.
Okay.
His father is here, sir. Would you come up?
All right, on page 10, who's over at the main jail?
I believe it is Mr. Hill.
All right, Mr. Hill, on page 10, we need Perry Lethbridge. On page 10.
Corey, do you have Mr. Lethbridge over there? Page 10?
Lethbridge! He's coming. Judge, the first thing we're gonna need on Mr. Lethbridge, please, is an order to allow him to be seen by the doctor. He's having severe pain in his back and nerve damage, so if we can get an order that he can see by medical immediately,
Sure.
please.
I'll be glad to draft that order. We also have his father, who is the victim in the case, present here this morning. And I think his dad can shed a lot more light on Mr. Lethbridge's situation than I can possibly explain in the short time that I've been affiliated with the case, which is about 5 minutes. Mr. Lethbridge, is there something you would like to say or recommend to the court?
Yes. My son was in a Baker Act facility for about 9 days and was to be released to another facility, which that did not work, so he ended up coming home. He's in need of mental health and substance abuse treatment, and we're in the process of obtaining a guardianship action for that. I'm not injured. I'm not injured at all. There's no injuries to me, and the plantation police had transported him to the hospital yesterday. He was supposed to go in there. He went into the hospital, and they did not follow up on it. They just left, and then he walked out and was in a hotel, and so we were trying to get him to come back home, and that's when this occurred.
All right.
So we're looking to put the guardianship in place and have him taken to a facility for treatment. Not in, there's no crime committed, I'm not injured, and, they should have, they told me when they were taking him to Florida Medical Center under a Baker Act. Then I find that they removed the Baker Act when they got there instead of putting him in. It should have been put into a Baker Act facility, and then we could have seamlessly transferred him to a facility for treatment. But this happened, I don't know why. And so that's why we're here today.
Well, I don't know why either, because the report does say that they took him to Florida Medical Center to be treated.
And we don't know
And
what the
there's
doctors
nothing else
that are-
after that
Right.
about what transpired. So I am not going to assume anything after that.
The only thing I
because-
have is word from Florida Medical that they, the plantation police withdrew that for whatever reason. They had a Baker Act, and then it was withdrawn. So why they would withdraw it, I have no idea. When they get there, they tell me they're doing one thing, and then another thing happens. So,
Okay.
and
Well, all right.
he's a danger to himself to be out, and he can't come to our house. He needs to go to a facility, which we're arranging.
Judge,
Okay.
my conversation with Owen McNamee from our office, who's in charge of our mental health unit, we talked about this morning. What our intention would be to ask this court to sign an order ordering the sheriff's office to take Mr. Lethbridge to the nearest receiving facility under Florida's Baker Act statute. And upon release from the hospital, if and when they decide that he is able to be released, that he be transported custody to custody to a facility. The problem is, as I understand it right now, we're not sure exactly what facility that would be, and I don't know what the state's position on that would be. But it certainly appears to me as though he does meet the criteria, based on what the father has said, that he does meet the criteria for Baker Act. So I'm going to be asking the court to sign that order. Mr. Lethbridge, do you know what facility we want your son to go to, or
We're trying to work on the family center up in West Palm Beach.
the Family Center in West Palm Beach?
Right.
Mr. Lender?
Your Honor, obviously, I don't have an objection to the court signing a Baker Act order. Other than that, though, I'm going to be requesting that the court set a $2,500 bond in order no victim contact. Mr. Lethbridge's history out of Broward includes 2013 burglary of a dwelling, 4 counts of burglary, conveyance, and grand theft. In 2012, he was arrested for an alleged battery against Barry Lethbridge that was dropped. Your Honor, I have no doubt that he needs appropriate assistance with potential mental health, potential substance abuse issues. But at this point, we can't really deal with generalities about, well, a facility without knowing what facility, what the conditions are going to be. I think when there's more details to present to, and I guess in this matter, Judge Allspector, that can be addressed in a educated manner at that time. That being said, other than bond or no bond or ROR release conditions and contact or no contact, I don't know really what else the court should address at this time.
Well, seeing as we have all had this issue before us, similar issue before us this year a
Yes.
few times, and having spoken to the other mental health courts, I am going to treat this in the same way that I treated the other matters, which is I'm going to set a bond. I will sign the order for him to be Baker acted, and then anything further, there has to be a hearing to be set before his division, a judge. Okay? So the charge is battery on a person 65 years or older, and I'm going to set a $1,500 bond and no victim contact. That doesn't mean, Mr. Lethbridge, that you can't do all the things that you need to do. It's just that both of you can't be in the same place. So all the other phone calls that you need to make to get him into the other facility after he's released from the Baker Act facility, you certainly could,
Am I
are
able to
able
talk to him on the phone or no?
no,
So
right?
he can talk to my wife.
Right, so no victim contact, and I will sign the order. Mr. Reed, if you'll prepare that order.
will.
I will sign it so that, he can
That
be
Broward
released.
General?
They.
Most likely.
Is that the nearest? It's,
That's what we were looking.
It's
Well-
really, I think it's impossible to know exactly at this moment, and frankly, I don't know if it's necessarily something we should.
right,
Even
they,
be discussing.
I can't write that in the order. I'll
He
have
has,
to.
he has insurance in Broward.
I know, but I have to write to the nearest facility, because if I write Broward General and they don't have room to take him, then that creates a problem. So if I
Also,
do
there
the
are security
nearest,
concerns as well.
right, and then they also have to take,
See
okay?
him being, he's never had been a
Judge,
security.
Well,
Mr.
from the
Lethbridge-
sheriff's perspective.
Personal.
Mr. Lethbridge would like to say something?
I would like to ask the court and ask you, Judge, I had called the plantation police and tried to get help for my manor in the last 2 days, over 15 times. I had had different officers, different patrolmen out there. I had talked to their sergeant, and my dad has what's called rich white man privilege, in which he never gets in trouble for anything. And as soon as they see me, they pat me down like I'm a monster because I've gotten in trouble because of him in the past. I've gotten in trouble because of his drug addiction, because of his inability to stop stealing my pills, which keep me calm. I've gotten in trouble because of his inability to stop.
Mr.
consuming
Lethbridge,
alcohol.
I'd advise you not to say anything further at this point.
Who's advising me? I can't see.
I'm the guy with the white hair in the
other
lower
attorney from the public defender's
One of the
office.
attorneys.
So, Mr.
Public defender.
Mr. Lethbridge,
Yes.
the young
Okay,
Perry Lethbridge. Corey,
Okay.
just Mr. Hill, let me just finish talking to Mr. Perry Lethbridge.
To the point.
All right, Mr. Perry Lethbridge, I want to let you know that I understand that this situation is not the easiest circumstances to be in. And based on some of the things that you've said, you want to be in a place where you can get the treatment that you need. So it is my attempt at this point in time to get that ball rolling, okay? All right, Mr. Father, it's good to have you here this morning.
Yes. Thank
All
you,
right.
Your Honor. Sure.
All right, the next person that the jail wanted to call out of order is that August Rulo?
Stop.
I think Mr. Rulo is going to be a medical reset, Judge.
Your Honor, he's gonna be a medical reset. We have to send him back.
All right, Mr. Rulo's a medical reset,
And the case immediately before that is Nabil Sadiq.
okay? So Nabil Siddiq? All right, Mr. Siddiq, you're before the court this morning. This is an ad charge for grand theft. And the court does find probable cause. Does anyone wish to be heard as to bond?
Yes, Judge. What page are we on? Thank you.
16.
You're on, oh.
Judge, in speaking with Mr. Siddiqui, he is fine with the bond that's currently set, so we'd ask that the $1,000 bond be kept in
He has
place.
other holds?
He has no bond holds.
All right, so, the bond of $1,000 will remain in place. Mr.,
Judge, I'm sorry, can I ask what the no bond holds, because they're not present on page 16 of the docket? What is the no bond hold for?
the state has informed me that he has other no bond hold. This is an ad charge.
Okay, thank you.
Mr. Hill, up to what page do you have persons in the room? Because I have someone here who signed in for page 25. Is he in the room? Gregory Filia?
No, Judge, it looks like we have people beyond page 25.
All right, if we can get him, there's a private attorney here.
I was advised that Mr. Filial was in the room, Judge.
All right, Mr. Interpreter, I see you, but I have one thing that I need to handle before I call your cases, okay? On page 4, Joyce Dimby. Good morning.
Good morning, Your Honor. Scott
Private
Sherman
services
on
of the
behalf of
PD.
Ms. Nimby. We're in luck, Your Honor. I've known this defendant for over 20 years. She's accused of spitting in the face of a elderly or disabled man. She is not accused of striking him, touching him, hitting him, punching him, or slapping him. She is not accused of actually causing any physical harm whatsoever to the alleged victim. My client is 53 years old. She's lived in Broward County most of her life. She is also mentally ill. She currently has a residence here in Broward County. She has had most of her life. As I said, she's mentally ill. She's been under the care of a psychiatrist. She has been continuously declared judicially incompetent for more than 20 years. She is currently on pretrial release with Judge Ginger Litterin. She has been on pretrial release since October of last year in mental health court on a misdemeanor battery. She was on pretrial release when this incident occurred back in May 4th of this year. If you read the probable cause affidavit, you will see that the alleged victim says that he identified my client at a previous court hearing. That was a hearing in front of Judge Ginger Litterin where they took my client into custody, kept her in custody for 2 weeks, released her on an electronic monitor with very specific conditions. She can only leave the house Monday through Friday to go to counseling with Dr. Samuel Kelly at Dynamic Health. He has a counseling program 5 days a week where she goes Monday through Friday. She has a.
Counselor, what are you asking?
I'm asking the court to release my client on pretrial release, ROR, with the same terms and conditions that she is currently on.
Are you aware that Judge Ginger Lerner yesterday, was it August 1st, signed an order to take her into custody?
Yeah, that was because she appeared in court yesterday for a status hearing, and the order was signed because there was the outstanding capias. So she basically self-surrendered herself in court. She's known about the fact that this charge was coming since May 4th. She has continued to appear in court every month. She has continued to go to counseling. She has been diagnosed, Your Honor, as
Is she currently on some release condition?
Yes, Your Honor. She's got an ongoing misdemeanor battery with pretrial release.
With who's the judge on that case?
Ginger Litterin, she has an electronic monitor. She is on level 2 house arrest with certain specific conditions. As I was saying, she can only leave the house Monday through Friday to go to counseling with Dr. Kelly. She can go to her counseling with her psychiatrist. She has a window on Saturdays that she can go shopping over a specific period of time. And she has a window on Sundays that she can go to church.
All right,
It's-
let me hear from the state, please.
Your Honor, the state is going to be requesting a bond and that should be placed back on a GPS monitor. I don't know that the court should be bound in dealing with this matter based on how Judge Lerner Wren has been handling the battery case. The reason being is there are different limitations pursuant to state law and how a misdemeanor can be dealt with when there's mental health issues and how a felony case can be dealt with. For instance, someone cannot be put in a state hospital on a misdemeanor case. The court should be aware, on at least 3 occasions, she has violated her pretrial release on that pending battery. One of the times, and it's referenced in this case, she spit on the victim of the battery when she had a chance encounter with her, who I believe happens to be the wife of the victim in this case. One time, Judge Lerner Wren remanded her into custody for inappropriate behavior in court. And that was as recently as June 20th of this year. Your Honor, my concern, and I'm not trying to be punitive, but my concern is Ms. Nimby, throughout her criminal history, has had allegations of violence that have been dismissed or dropped based on mental health reasons. 2006, there was an aggravated assault with a deadly weapon, a battery in '03. a battery in 2013, a battery in '05. She did plead out in '98, a battery on a victim over the age of 65. My concern is, and I understand what counsel is saying, but, and I know Judge Lerner tries to do her best, but it doesn't appear to be working.
I beg to differ with the state, if I may, Your Honor. There is no relationship between the alleged victim in this case.
Okay, just please hold on a moment, okay? It's attempting to call Judge Wren. All right, for purposes here today, I have found probable cause, and I am going to impose a $1,500 bond. Ms. Dimby's on other pretrial release conditions, so I'm not going to add any other, except to say no victim contact.
Your Honor, my
Is she,
concern
is she on an ankle monitor? And
She is on the misdemeanor case. My concern is, and maybe pre-trial can answer this, without it being ordered back on,
she's not,
okay.
it'll be back on because this was not a revocation. Okay,
So,
so,
but Your Honor's not inclined to just have that attached to both cases, so if she violates, then it can be brought to Judge
I want
Duffy's
to have
attention?
two things. Which judge is this matter?
Judge
Oh,
Duffy.
All right, so whatever the conditions are that she's already on for pretrial, we'll just leave those in place, okay?
Thank you, Your Honor.
All right.
And obviously, no victim.
You have all that information, right, for pretrial?
Yes, I have it.
Okay.
Need me to do a short order, or is that gonna be done?
No, they'll do it, Mr. Sherman, thank you.
Thank
And, Your Honor, just, I'd ask for no victim contact.
Yeah, I did say that.
Oh, I apologize.
Yeah.
Thank you, Judge.
All right,
$1,500.
yes, sir.
Thank you.
Okay. All right, so, how many people do we have for that needs a Spanish interpreter?
Oh, it's already filed. It goes to Elder Abuse Unit.
We have one in North
Here,
Row.
let me see. What's the
Who,
case number?
good morning, what's the name?
Chairman Itiago.
She's on page. Chicago,
No, it goes to FGU.
Perez.
It's the first case of the document.
It's the first case on the docket? Oh,
Going by
this
the book and
Tirago
everything, yeah.
Gutierrez. All right. Do you swear affirm to translate, to interpret from Spanish to English and English to Spanish?
I do, Your Honor. For the record, that's Igor Felicioni. Good morning, Your Honor.
Good morning. I have Sheni Itriago Gutierrez.
Tengo a la señora Shani Itriago Gutiérrez.
Ms. Gutierrez is before the court this morning for one charge of aggravated assault with a deadly weapon. It's domestic.
La señora Itriago Gutiérrez se encuentra frente a la corte el día de hoy con un cargo de agresión física agravada por el uso de un arma mortal en el ámbito de violencia doméstica.
The court finds probable cause.
La corte halla causa probable.
No, Ms. Gutierrez, I'm not, don't say anything yet. Does the state,
No, señora Gutiérrez, no diga nada todavía.
Okay.
does the state have, does Ms. Gutierrez have any priors?
La señora Fiscalía se le pregunta, ¿la señora Gutiérrez tiene antecedentes?
Your Honor, I did not see,
No.
I did not,
Please say nothing, ma'am.
Señora, no hable.
I did not see any history.
No, la fiscalía no ve ningún historial.
Your Honor, I would be requesting a $2,500 bond.
La fiscalía en este momento solicita una fianza de $2,500,
Noting that she allegedly chased the victim through the house with a knife.
dejando claro que supuestamente la señora persiguió a la supuesta víctima por la casa utilizando un cuchillo.
He had to retreat to the bathroom and lock the door for safety.
Él se tuvo que retirar al baño y trancar la puerta
And though she
para
denied,
seguridad.
though she denied this, it was corroborated by her child who witnessed the incident.
Y a pesar de que la señora negó esto, esto fue corroborado por su hijo o hija que corroboró el hecho.
No,
Well, because of the language barrier. Because of the language barrier,
Dada la barrera del lenguaje,
I have not been able to speak with Ms. Itiago Gutierrez
el abogado de la defensa no ha podido hablar con la señora Itiago Gutiérrez
as to where she might reside. Well, she would not have to have contact with the victim.
sobre temas de dónde pudiera vivir en caso de que se le ordenara que no tuviera contacto con la víctima,
Or what her financial resources might be.
ni cuáles son sus recursos financieros.
In light of the fact that she has no prior criminal conduct on her record,
Pero a la luz de que la señora no tiene ninguna conducta criminal en el pasado,
I would be asking the court to consider releasing her to pretrial release
en este momento la Defensoría le pide a la juez que considere liberar a la señora bajo su propio reconocimiento,
without the need for posting a monetary bond.
sigue el uso ni la necesidad de una fianza monetaria.
My main concern
Mi preocupación principal
is where she would stay or where the victim would stay so that they do not need to have contact with each other.
es dónde se quedaría la señora y dónde se quedaría la víctima, de manera tal de que pudieran mantener distancia entre ellos y que no haya contacto entre ellos.
Is there somewhere else that you can stay, ma'am?
En este momento le pregunto, señora, ¿hay un sitio donde usted se pueda quedar?
bueno, yo aquí no tengo familia.
I don't have any family here.
What about your husband? Can he stay somewhere else?
¿Y su esposo se puede quedar en otro sitio?
Mi esposo dijo que él no pondría cargo.
My husband said he wouldn't press charges.
That's not my question.
Eso no es lo que le estoy preguntando.
The judge is going to sign an order
La juez va a firmar una orden
stating that you may not have any contact with him.
indicando que usted no puede tener contacto con él.
You cannot live in the same place.
No pueden vivir en el mismo sitio.
The judge has no jurisdiction over your husband to force him to move.
La juez no tiene ningún tipo de jurisdicción sobre su esposo para obligarlo a él a mudarse,
But she does have jurisdiction over you.
pero sí tiene jurisdicción sobre usted.
Okay.
Do you have a friend you can stay with?
No tiene una amiga con quien se pueda quedar.
No me puedo quedar con la hermana de él.
I can stay at his sister's.
Okay. But
Que vive en,
you understand you cannot have any contact with him.
Pero usted entiende que no puede tener contacto con él.
okay.
Okay.
Judge, I'd be asking for a
All right.
pretrial release.
I'll ROR her to pretrial supervision. No victim contact.
En este momento la juez está emitiendo una orden de liberación bajo su propio reconocimiento, bajo las condiciones estándar de supervisión previa a juicio. No podrá tener contacto con la víctima.
Ma'am, that means no phone calls, no text messages, no social media, no third-party contact.
Señora, no tener contacto con la víctima implica no lo puede llamar, no le puede mandar mensajes de texto, no puede hacer publicaciones en redes sociales y no puede comunicarse con él a través de terceros.
You must report to the pretrial office.
Debe reportarse a la oficina pretrial.
If you don't get out on time by 4 p.m. today, you must report first thing Monday morning.
Si no la liberan antes de las 4 de la tarde del día de hoy, deberá reportarse a esa oficina a primera hora del día lunes en la mañana.
If you don't report, a warrant will be issued for your arrest.
Si usted no se reporta a esta oficina, será emitida una orden para su arresto.
Okay? All right.
Okay.
Good luck.
Buena suerte.
All right. Is,
Good luck, ma'am.
is there someone
Buena suerte,
else
señora.
who needs a Spanish interpreter?
¿Alguien más necesita el intérprete español?
All right, hearing nothing. Thank you.
Have a good weekend, Your Honor.
You too. All right, so have we determined if Gregory Filia, is he at the main jail? Is he in the room? He is in the room. Gregory Filia.
Judge, he's approaching. He's got private counsel.
Yes, he's here. All right, good morning, Mr. Filia.
Morning, ma'am.
Sir, you're before the court on one charge of aggravated assault with a deadly weapon without intent to kill. The court, I do find probable cause, and I'll hear from the parties. Okay?
Your Honor.
Yes.
Okay. Unfortunately, we tried, we've not been able to reach an agreement, so it'll be up to Your Honor. We'll kick
Okay.
it to you. Your Honor, I spoke to counsel, I'm gonna be requesting a $20,000 bond and a GPS monitor. This is based on the allegations in this case, the alleged use of a firearm. I am also concerned, Mr. Filial has a history of firearm offenses, weapon offenses. 2011, possession of firearm by convicted felon. 1998, possession of firearm by convicted felon, 10-year state prison as a habitual offender. 96, aggravated assault with a deadly weapon, violation of probation, 5-year state prison as a habitual offender. 91, armed kidnapping, robbery, firearm, or deadly weapon, 5-year state prison. 91, 2 counts of robbery with a firearm or deadly weapon, 5-year state prison.
Okay. Counselor?
Your Honor, we're not going to argue that Mr. Filial did not have a significant history at some point, but since 2011, he has been in business. B&G Demolitions has been doing quite well with that, has not had any other run-ins with the law. This particular arrest, Mr. Filial was arrested without even knowing what he was arrested for. His work truck was confiscated. They've gone through the truck. There was no weapon involved. Apparently there was some sort of argument. I think they're alleging there was some road rage. No one was injured. No one, there was no use of a firearm in anything. Mr. Filial didn't even know what this was about. Did not have a firearm, has not had a firearm in 10 years, almost 10 years. We're asking, he's been out of work for the last week just based on the fact that they had taken his truck. They arrested him last night. Again, Your Honor, did not know what they were arresting him for. Kept his truck for a week. He's lost a week of wages. Your Honor, we'd like to have him released, say $10,000. He has not had any trouble, as I said, in the last 9 years. And
All right, I'll grant the $10,000 bond. Okay?
thank you, Your Honor.
All right. No victim contact. I don't know if he's
Thank
gonna
you.
say he doesn't.
And Your Honor, it would also, even though he's not allowed
and-
to by law, that's for no firearms or
And
weapons.
no weapons or firearms.
Absolutely, Your Honor.
Okay?
Thank you.
You're welcome. All right. Okay. Tina Testaverde,
Medical reset.
medical reset. Haley Ford. Is that a?
Paul Ryan, Your Honor.
All right, Ms. Ford, you're before the court for a KPS. You did not show up for arraignment on July 24th. The judge did set a bond for $500. Ma'am, what do you wish to do today?
I want to resolve it as much as possible, Your Honor.
All right. Does the state have an offer from Ms. Ford?
The documented offer, Your Honor, is an adjudication court cost HIV test.
Okay. Did you hear that, Ms. Ford?
Yes,
Do you
ma'am.
wish to accept it?
Yes, ma'am.
All right, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. And Ms. Ford, do you understand the offer that has been extended to you today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
And ma'am, you understand that you do have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
In the past I have, but I got all that resolved.
Oh, so the answer to the question, have you ever been treated for mental or emotional illness is, what's the answer?
Yes.
Okay? And do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am, I understand.
And is there anything about that mental health or emotional health treatment that would affect your decision-making today?
No, ma'am.
All right. What plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication, time served, HIV test, okay?
Okay.
All right, good luck.
Ma'am, may I ask you, can I get an HIV test done before I leave jail?
I don't know if the jail provides that service. You would have to find out from the jail.
Okay, thank you.
Okay. All right, Mr. Plant stepped out? You're not Mr. Plant.
No. I know we're on the record.
No comment, no comment. All right, and then, are you first?
I signed in.
No, I know you did, but, on, page,
23, Sage Donati.
oh, that, is Mr., is it male or female? Are you sure, Mr. Reedy?
Yes, well, that's what I'm told.
All right.
Yesterday afternoon, I can't be too sure of anything.
On, page 23, do we have Sage Donati? All right.
Hey Sage, it's Michael.
Yo,
All right, Mr. Donati, you're before the charges that have been presented. I see charge one, robbery firearm.
It's, Your Honor.
So
That's a
it's,
mistake, Judge.
Yeah, it's,
I know.
Mr. Weinstein. and I
That's why
already-
it started out like that. It's there.
Mr. Weinstein and I already discussed that. The actual charge in the information is strong arm robbery with an aggravated battery.
All right. Have you both already discussed this? And
Not really, Your Honor, because, what I did discuss with Mr. Weinstein this morning, actually, bright and early this morning, counts 9 and 11.
strong arm robbery, okay.
Counts 9 and 11, the burglaries of structures causing damage over $1,000 are punishable by life offenses.
Counts which one?
9 and 11.
Okay.
The state is going to be seeking a no bond hold on those counts upon a finding of proof evident or presumption great for first appearance purposes only. Obviously, if the court makes that determination, Mr. Weinstein is not precluded from seeking an Arthur hearing in front of the assigned judge where the state would again have to satisfy proof evident or presumption great at that hearing. Your Honor, I'm relying upon the affidavits attached where I believe in both of them, Mr. Donati confessed to committing the offenses. Your Honor, I would ask, should the court make that determination that you do not exercise your discretion in setting a bond, this is just based on the totality of all the offenses that are before the court. I would also note Mr. Donati's criminal history. As you can see on the booking sheet, at a minimum, the Department of Corrections has placed a 72-hour parole hold on him for the parole board to determine if they're going to put a hold on him. This is based on 2016, a grand theft where he was sentenced to just over 25 and a half months state prison as a habitual offender. 2015, burglary structure, same sentence. 2015, grand theft, same sentence. 2016, grand theft auto on grand theft, same sentence. A felony petty theft, where he received the same prison sentence, he wasn't qualified as a habitual offender in that case. 2015, burglary of a dwelling with a violation of probation, 50 months state prison. Grand theft auto, 2014, with a violation of probation, 50 months Florida
Judge,
State.
I hate to interrupt the state, but one, they're trying to conduct an Arthur hearing here, and we're not really here for that. I'm not disputing what the statute says, so we're gonna go in front of Judge Bober for that. I think the only thing we're here for is to set bond on the count the court had already mentioned.
I think I can consider the prior history.
Oh, absolutely, I'm just talking about the Arthur hearing,
No, no,
why they're
and-
talking about proof evidence.
Just to clarify, this is not an Arthur hearing pursuant
Oh,
to
I see what you're
SAZA.
saying.
And the judge, and the courts are clear that, you know.
Go ahead.
And Your Honor is familiar, even if you find proof evident or presumption great, you do have the discretion to set a bond on the PBLs at this time if you so choose. So I'm just providing these aggravating factors to attempt to persuade the court, if you do make that finding, not to exercise your discretion at this time. Mr. Donati was released from state prison April 9th of this year. As you can see, on count 13, he has an out-of-county hold out of Dade County for a separate burglary of a structure. Certainly, I do believe Mr. Donati presents a danger to the property in the community, and based on the allegations of the robbery, which I think the court can take into consideration to determine if there should be a bond or no bond, I do think he poses a danger to the safety.
I think logistically, the state's putting the cart before the horse. The first thing we need to consider is he's entitled to a bond on the strong arm, because it was typed incorrectly or whatever, for whatever reason they put it as robbery firearm. He's entitled to a bond. He's already got several significant bonds, 11,000, 1,000, 7,500, 1,000, 25,000, 1,000. So he's got significant bonds already. I would ask that you just set a reasonable bond on the robbery. As far as the PBLs are concerned, I will deal with that in front of Judge Bober.
If that's the case, Your Honor, I have no objection then on the burglaries. I would ask if I could just present some additional information on the robbery, Your Honor. I think
Okay.
the court should be aware, I did have an opportunity to speak to the son of the victim this morning in this matter. He did advise me she did suffer injury from this incident. She had bruises all over her body after she was struck by Mr. Donati's vehicle. She does have safety concerns, so I think the court should be aware of that. I'm going to be requesting, and it is a first-degree felony, a $50,000 bond.
Which one are we talking about?
Count one,
Okay.
a $50,000 bond, no victim contact.
All right, Mr. Weinstein.
Judge, I'm not here to litigate the cases. I think that I have read that file, and I believe that it is, I'm not saying there's anything good about committing an attempted robbery or a robbery, but I think that the facts as charged are more significant than what actually happened. So I would just leave it at that. Regardless, he's still entitled to a bond on charge number one. I think 50,000 is a little high, taking into consideration all the other bonds. That's number one. Number two, he's going to have a Dade County hold, and he's going to have a prison hold. So I'm asking logistically, no monitor at this point. I think it's very significant. Let me explain why. He's going to go, if they've got a prison hold on him, if he bonds out, he's going to go back to prison and then, or first Dade County and then prison. So he'd have to post thousands of dollars before he even had a chance of getting out. And he's being held on a PBL. So that's assuming Judge Bober even gives him a bond. So if we do the monitor, it's going to turn into a logistical nightmare.
If the court is inclined to hold no bond on the PBLs, I wasn't going to make a request for a monitor because it's a moot issue at this point.
I just logistically, at some point, I'm going to try to get him to Miami to resolve that case.
Okay.
If any court puts a GPS hold on him, it stops everything, and I've got to do 2 separate orders to get him transported.
Well, he does have several no bond holds, and he's got no bond on.
Yeah, I wasn't requesting.
So I don't think he. Did
don't
you
think I
request
said it.
that?
If I
That's
did, I
why I was
apologize.
laughing because I don't think you requested that.
I'm anticipating that.
Mr. Weinstein's used to my request.
Yes.
So.
I just
No,
asked,
I'm not asking for that.
Say, just so you know, we're not laughing at you. at
We're
all. You know
not.
that.
We're just laughing at how this whole everybody's anticipating what the other one is going to say. And
All I'm asking for is on count one, the court set, because he's entitled to a bond. 50 is a little high, taking into consideration all of the other significant bonds he has, the 25,000, 7,500, et cetera. I would ask for a bond in the realm of 15 to 20.
All right, so we'll leave the no bond holds on the other ones. You'll deal with that in front of Judge
Judge Bober,
Bober.
I've already got a court date.
Great. And now on count one, is he gonna have to, if I change it on the paperwork? Because on the booking
It's
sheet
already
has the
filed,
correct.
so we don't have to worry about one of
Oh,
those
you-
change of charges.
And it is filed as a strong-armed
It's,
robbery?
I checked the information, Mr. Weinstein's seen the information, it's a strong
I-
arm robbery with a
I just
aggravated
want to make
battery.
sure,
Of course.
okay? All right, so what I'll do is I'll set a $25,000 bond,
Thank you, Judge.
okay?
And Your Honor, just an abundance of caution.
And no victim
And
contact,
no return to any of the
and no return to, what is this location?
There's a Publix on 4701 South University Drive in Davie. There is, one moment.
Here's a few,
There's a Subway. There's my Big Fat Greek Restaurant at 3445 Griffin Road in Dania Beach. And one moment, Judge. Mike, is the Subway, if you recall, was the Subway in Hollywood? Mike,
Say that
if
one
you
more
recall,
time.
was the Subway in Hollywood, allegedly?
I believe so.
So we just asked the Subway in Hollywood in this matter, I'm sure. You know, if Mr. Donati wants more specification, I'm sure Mr.
all right,
Weinstein
Mr.
will provide.
Donati, just so you know that there's a no return to these locations, and you can have further conversation with your attorney, okay?
Yes, ma'am.
All right, good luck, sir.
All right, Sage, I've got a depot this afternoon, so I'm not coming to the jail, but I should see you in court on Monday, okay? All right, I'll see you.
All right, on page 11, Nelson Mackinson Nelson. Last name Nelson, first name Mackinson.
Yes. Your Honor, this matter was reset from yesterday so I could have Detective Innocent Doles appear before Your Honor to provide testimony.
Okay.
Morning, Your Honor.
Good morning. Can you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Okay, please state your name for the record.
Detective Lorette Innocent Doles.
State.
Thank you, Your Honor. Detective, who are you employed by and in what capacity?
Fort Lauderdale Police Department, Special Victim Detective.
And how long have you been a detective with Fort Lauderdale Police Department?
12 years.
Did you have an opportunity on July 31st of this year to investigate an allegation of numerous criminal offenses committed by Mackinson Nelson?
Yes.
And as part of your investigation, did you have an opportunity to interview the alleged victim, Renaya Colas?
Yes.
Okay. Could you please tell the court what Ms. Colas advised you as far as what occurred in this incident?
She said her mom got up early to go get breakfast for her. She was asleep in her room with her younger sister, 11-month. She heard banging on the door. She knew who it was because he'd been doing it for a couple of weeks, and her mom has refused to let him in. So she ignored it, and she heard banging on the window of the living room. She ignored that. So she said the subject went around to her window, banging on her window. She ignored it. She put a cover over her head, and then she heard something moving from the window, so she took the covers out, and through a mirror, I believe, that's facing the window, she was able to see the subject move the accordion, I think it's accordion she was explaining, that's attached to an AC, a portable AC, and then all of a sudden the portable AC was pushed inside. She said the subject entered into her room and called her name and nudged her and told her to get up, call your mom now. She said she acted like she was sleeping, so she walked down the hallway, woke up her brother, and she started dialing her mom, but her mom was not answering. She said the subject threatened to kill all of them if her mom did not get to the house. So she attempted to call her mom a couple of times, and then her mom answered, and her mom was like, "What's going on?" And then she said, "Hey, he's here." And her mom asked, "How did he get in this house?" And she was like, "I didn't let him in, he came through the window." And then the subject grabbed the phone from her and started calling her mom, explicit word, H word, all kind of names. I believe her mom hung up the phone, and she said the subject threatened them again to kill them if the mom didn't get there. He punched the walls a couple of times that scared them, and then took a TV that was mounted on the wall and pushed it or slammed it against another wall across the room. She said the subject picked up the 11-month-year-old, took the 11-month-year-old with him, and they called their mom and told them not to come back because I think he's waiting in the parking lot. They snuck out of the house in the back door and went behind a couple of houses to somehow get in front and go to a grandmother's house, the boy's grandmother's house. And then from there, they called their mom. And that's what happened with her, with Naya. But
Okay, thank you. Detective, did you also have an opportunity to interview one of the victim's children whose initials are DM? Or is that, she has...
Renaya is the 14-year-old.
Did you, well, let's not give the names of my, did you, what's what are the initials of the 14-year-old?
RC.
RC. And did you have an opportunity to take a statement from that
Correct,
14-year-old
yes.
juvenile? Did you qualify?
Yes.
The witness. And what did the 14-year-old?
Just what I explained now. That was her.
What
That was
did
her
she tell you?
statement.
Oh,
I just said it. That was her statement.
one moment.
The mom name started with M. MT.
One moment, Your Honor. One moment. Monica Thermidor is the
Mother.
and she was present when this occurred?
She was not present.
Okay. Your Honor, can I have one moment?
Sure.
Were you able to observe the inside of the residence?
Yes.
And what you observed, did it corroborate the allegations of the damage done to the home?
Well, I came a couple of hours afterwards. They called me out. I came a couple of hours afterwards. I had officers take photos and also process the scene. But I did take a statement from the mother, MT.
So officers took photos of...
Correct.
Did they describe to you what they saw at the scene?
Correct.
And they did?
Yes.
And what they described, did it corroborate with the allegations by the victim of the damage done to the home?
Yes.
Your Honor, I have no further questions.
Okay.
Your Honor, I would be seeking a no bond hold upon the finding of proof evident or presumption great. Oh, Your Honor, I'm sorry, could I just ask one more question of the detective, please?
Sure.
Okay. Detective, it's mentioned that there's a history of domestic violence. Could you please advise the court what you were advised by the victim as far as this history of domestic violence?
Judge, I'm going to object to that. If the state is asking for the court to make a finding of proof evident presumption great, it should be confined to the four corners of the reports before the court and the testimony of the detective. Anything else other than that is being brought up purely to inflame the court and encourage the court to make a finding of proof evident presumption great based on facts that should not be considered by this court at this point of the proceedings. If the court decides to set bond, then those matters become relevant. But as far as a determination of proof evident presumption great, whatever has happened in the past does not have a bearing on this case here.
Your Honor, I would disagree. One, the burglary with assault is not the only charge before the court. There's a stalking charge before the court. Certainly, any evidence with respect to the stalking charge can be considered by the court. Additionally, it's a burglary with assault with, let's see, an additional count of assault against this same victim. Certainly, the court can consider with respect to level of fear if there has been prior violence.
As to the stalking, I would agree. If there's anything the detective can testify, which again is probably going to be hearsay upon hearsay, that's fine. Stalking, I agree. If there's evidence of stalking, is the state seeking to ask the court to find proof evident presumption great as to the stalking charge?
And I'll address the court directly instead of Mr. Reedy.
And if
Your Honor-
not, then anything regarding the stalking has no bearing on the determination of whether or not proof is evident or presumption is great.
As far as making a determination, probable cause on the proof evident presumption great, we're talking about count one.
As far as that count, yes.
All right, so let's just finish the argument, whatever presentation you have as to that.
Okay.
And then we'll talk about.
Understood, Your Honor. Your Honor, I would just be relying upon the testimony and the affidavit attached with now you've received specific information regarding the statement that the detective took. It is mentioned that the other witnesses were spoken to and corroborated that version of events.
Well, we would object to the court making a finding of proof evident presumption great. The detective was nice enough and kind enough to come in here this morning, and the state requested the case be reset an entire day so the detective could give testimony. But the detective didn't witness anything. And the detective is not a witness in this case as to what took place. The detective indicates that the witness was qualified and that she was satisfied that this witness is capable of telling the truth, this juvenile witness. But we don't even know if this detective is qualified to qualify a witness. Certainly, if the detective was kind enough to come in here today, she could have brought photographs with her. She could have brought some physical evidence with her, anything to corroborate the account of a witness who is not here. So the state is not, they've gone out of their way a bit. They asked the case to be reset an entire day to present evidence to the court, and they presented no eyewitness evidence. They presented no physical evidence. They're relying solely on the testimony of someone who did not see what allegedly took place. And I just don't understand why the state would ask for 24 hours to bring a witness in and have the witness not bring any evidence with her. Where are these photographs that corroborate the victim's or the witness's account of what happened at the scene? Where are the photographs of the air conditioning unit? Where are the photographs of the house being in disarray? Where are the witnesses to testify to that? They haven't done any of that. They asked for 24 hours to do absolutely nothing.
All right, at this point in time, there's not been anything more than what's already in the report. I'm not gonna make a preliminary finding of proof evident presumption great. So let's talk about bond. And,
Well, Your Honor, I would then like to ask the detective about the previous violence, previous
okay.
domestic violence.
At this point, I would say that is relevant.
Thank you. Detective, you were advised by the victim about previous domestic violence by Mr. Nelson?
Correct.
Could you please advise the court what you were advised of?
She told me about a previous time where he pulled a gun on her. Didn't say he was going to kill her, but he was aggressive. They were in an argument. They got into multiple arguments before where he was very aggressive. The victim told me that she never filed a police report. The victim in this case here stated to a bunch of stalking where he would sit in front of her parking lot, waited for her to come home. There was time where she switched cars with her cousin just to throw him off, and he knew and he would call her all kind of names and knew that she switched cars. And that's how the banging of the doors, he would come over trying to find out where she was. At one time before she was nice enough to let him see the 11-month-old child until it was getting to the point where she was like, okay, you cannot come see the child unless you call me and we can meet somewhere. He was coming whenever he wants, uninvited, and calling her, trying to figure out who she was with, where she was, that type of stuff, so.
Thank you. And just one last question. The victim's, I guess, two sons, with the initials DM and MM that were also present, how old are they?
One is 12 and the other one's 11, I believe.
Thank you. Your Honor, I'm going to be requesting a $50,000 bond on count 1, $2,500 bond on counts 2, 3, 4, and 5, a $15,000 bond on count 6. Pretrial release with a GPS monitor, no victim contact, no contact with any of the parties mentioned in this matter in the report. As far as his history, Mr. Nelson has a 2013 attempted armed burglary of a dwelling. 2011, possession of cannabis with intent to sell. 2011, possession of cannabis with intent to sell. 2011, resisting without violence. 04, delivery of cocaine with a violation of probation. 03, possession of cocaine with a violation of probation. Your Honor, we have an allegation that Mr. Nelson broke into a home that was occupied by 3 juveniles and an 11-month-old. He took the 11-month-old. He threatened to kill children. He has been stalking this woman repeatedly from the description. He damaged property in front of the children. You've been advised under oath, and the sworn statement was taken from the victim, who advised the detective under oath, that there's been violence in the past. He has a prior for trying to break into a home while armed. So I have a great concern for this, not only the safety of the victim, but her children.
All right, thank you. Thank you, Detective. Defense? That's the bond?
Thank you, Judge. In regards to a monetary bond, Mr. Nelson at this time would only be able to afford a maximum of $1,000 on his end. As a result of that, I'm assuming these total of 6 counts, the 6 bonds that will be set, will exceed any amount he will be able to post. So as a result of that, Mr. Nelson is asking the court if the court would consider pretrial release.
All right, that will be denied at this time. Pretrial will be denied at this time. As to count 1, I am going to impose $50,000, 2 through 5, 25,000, and then on count 6, 15,000. If Mr. Nelson posts his bond, he'll be on a level 2 pretrial. No victim contact. And that means, sir, no phone calls, no text messaging, no social media, no third-party contact until further order of the court, okay? All right, Mr. Plant.
Thank you, Judge.
All right, Mr. Plant, on page 12, can we have Richard Crump?
Judge is approaching.
Okay.
Judge, I understand this is an MO. Okay, we have Mr. Plant. Good, thank you.
Thank you, thank you.
All right, Mr. Crump, good morning.
Good morning.
Yeah, Mr. Crump, you're before the court because you have 2 misdemeanor capias on July 1st. You did not show up for your arraignment. And on July 2nd, there was another capias issued for you. So that's the basis for your 2 capiases. Mr. Crump, what do you want to do today?
I'd like to resolve it if possible.
All right. Mr. Crump, when you have a court dates, you have to show up for them. It's easier to resolve it that way than have to come back before the court on a capias for missing court.
Yes, ma'am.
All right. So if you wish to resolve your case today, I'll sentence you to adjudication and time served. Do you wish to accept that?
Yes, ma'am.
All right, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, sir, you can put your hand down. And Mr. Crump, do you understand what we've discussed here today about your case?
Yes, ma'am, I understand.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
And sir, you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, I understand.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And sir, do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, I understand.
What plea do you wish to enter, Mr. Crump? Guilty or no contest?
No contest.
All right, sir, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication and time served. Good luck, sir. Give him 6 months to pay the court costs. Michael McKeon on page 15.
It's on medical loan, Your Honor.
Mr. McKeon is on medical loan, thank you. And then Rashawn Withers on page 30. Is Mr. Withers in the room? Did you check, Mr. Plant? He's way down
Rashawn
on the
Withers.
docket.
He may have bond.
I mean, no, he has a no bond
No
hold.
bond on the
He has
felony.
a no bond hold on a felony. Is Mr. Withers in the room?
I'm getting it now, Your Honor.
Okay, thank you. Oh. Where's Kiana Watts Bernard? Oh, she's at the main? All right, let's handle Miss Bernard. Ma'am, you're before the court for carjacking without a firearm or weapon. And the court does find probable cause. Which one? Yes.
Conditions of pretrial release was your intention to order no firearms, weapons.
Yeah.
I figured it's because it's standard.
Yes. All right. Okay. All right. Are we ready to address Ms. Watts Bernard? Carjacking?
Yes, Judge.
Does she have any priors? This is, oh.
Come on, man. And you ain't ready for that.
Nothing as an adult, Judge.
Okay. All right. Mr. Hill?
Thank you, Judge. Judge, as the court can see on the docket, the bond is set at $75,000. That is not something Mrs. Watts Bernard is able to post at this time. She is gainfully employed. She's 21 years of age. She indicated to me this is her first time ever accused of a crime in her life. She has no children.
Oh, they just said she has a juvenile history. The state just said that.
All right, I apologize for that. As a result of the bond being set, I'm assuming it's gonna be a high amount, Judge. She's not able to post anything financially. She's asking the court if the court would consider pretrial release with an ankle monitor.
Your Honor, the state would oppose outright release to pretrial. I understand she has no adult priors, and certainly I understand the court taking into consideration her financial situation. That being said, this is a first-degree felony offense. There does appear to be a fairly high level of violence alleged to have been committed when she stole the victim's vehicle. So I would ask the court to take that into consideration, obviously in order of no victim contact.
Well, it does, it appears, based on the allegations, that there is some kind of pre-plan. As, this was, someone that they met on Plenty of Fish. Not heard of that app, which, so,
Judge, we can't get into the facts of the case, but Ms. Watson Bernard wanted me to let the court know that it was her that was attacked.
well,
It was her that was set up.
okay, well, there will be a time for her to put on her defense, but I have to make a determination based on the allegations that I have before me. And so, the allegations that I have before me is that 3 days before the incident, the alleged victim met her on Plenty of Fish, and then 3 days later, she's at the house and they're driving, and then there's that attack on, to take the car. So I have to take that into consideration. She'll have a later time to put on her defense, but that this time I do find probable cause. And I know that there's also a history, though not an adult history. So I am going to impose a $25,000 bond. And she will be on a level 2 anchor monitor. She's to have no victim contact. And no return to that location. Ma'am, no victim contact means no phone calls, no text messaging, no apps, no third-party contact. Do you understand that?
Yes, ma'am.
All right. Okay, all right. Do we have Rashawn Withers yet? Was that who you were speaking with? Oh, okay.
There he is.
All right, so Mr. Withers, you're before the court because you have a violation of felony probation with a no bond hold, and then you have 2 misdemeanor capiases, and those have bonds attached to them. But
He wanted to resolve the misdemeanors, but he goes to court for his VOP on Tuesday. He's not aware of how he violated.
you mean on the probation?
Right, on the probation, he goes to court, looks like Monday, in front of Judge Usan.
Will those affect his
It
felony
happened
charge?
after, it happened after,
I can't see that it's happened after?
according to
What's
the
the
date,
date?
but he's not aware of,
All right.
it's
And it's a petty theft and a resisting without violence. He did not show up for arraignment on July 15th. That's 1 KPS. And then the warrant for the violation was signed June 25th. No, yeah. He didn't make a report. He didn't report that he had contact with law enforcement. He's in arrears with his fines. It looks like there was another offense that was committed since he's been on probation. At this time, I'm not gonna, I won't resolve the misdemeanor matters, the municipal ordinance matters. He does have court on the 5th and the 6th on those matters, so they'll be better able
see you
to
there.
handle
I mean,
those,
we'll see him
okay?
there. We'll see you there, sir.
All right, good luck, sir.
Thank you, Judge. We'll see you
Yes.
Monday and Tuesday.
right, Mr. Linder reviewed
ma'am.
this order from the earlier one with the Baker Act.
Let me approach.
Do we want him to, just a Mavis Johnson, good morning. Is this again? Oh, yes. Major. All right, Ms. Johnson, you are before the court this morning. Charge one is fraud. Let me get to that page. I can see clearly.
Assault and
Charge
misuse of
one is
911,
fraud,
there's no
misrepresenting self, using a personal ID. Number two is petty theft. Number two is a felony petty theft, just to make it clear. Number three is illegal use of a credit card. Number four is grand theft. Number five is petty theft. Number six, fraud, attempting to use the ID of another person without consent. Number seven, illegal use of credit card more than 2 times in 6 months. Number eight, felony capias. Okay? All right, and the court does find probable cause as to all those counts. And does anyone wish to be heard? There are some standard bonds that are set in place.
Yes, Your Honor. I'm going to be requesting first that the court keep these bonds in place. Also, I'm going to be requesting a GPS monitor. I am somewhat familiar with Ms. Johnson. She appeared before, in first appearance last year on a criminal use of personal identification and a grand theft. That is still pending, and my understanding is originally that was going to be handled by statewide prosecution. Your Honor, there's a litany of cases with the same type of MO as in this one, and I can advise the court, because I did speak to one of the detectives this morning about this, that Ms. Johnson targets elderly people in supermarkets. She follows them, she waits till they're not paying attention, and then commits theft against them. That's what allegedly occurred in these matters. That's the allegation in the 2018 case. Your Honor, she has. One moment, Your Honor. That's what I was also going to advise the court. If you want to reset it for them, but it's all, and I'm sure, confinement can confirm it's similar type of charges. If you want to reset this for the
She's gonna
afternoon,
be
that's
on the
fine.
PM docket as well?
Yes.
All right, all right, then we'll see Ms. Johnson back this afternoon. There's gonna be additional charges that will be presented. All right? Okay, Eugenia Suggs. All right, Ms. Suggs, you're before the court this morning. Charge 1 is grand theft.
Sheila.
2 and 3 are felony violation of probations. Those both have no bond holds. You will be before your felony judge on Monday at 8:30. The court does find probable cause, and you have a $1,000 bond on count 1, okay?
Judge, Ms. Suggs wanted me to ask the court if possible, she's got a lot of responsibility, that she said she indicates she needs to deal with. She wants to know, is there a way she can go see her judge today?
I don't know how to make that happen. Okay. All right. Alexis Kubisky.
Good morning, Your Honor, Paul Ryan. Your Honor,
Yes.
yes, Mr. Bishke refused to come up today.
I would ask
All
the
right.
court to make a PC determination.
All right, so Ms. Kubisky has been reset several times. There was, it looks like since Monday. Then there was a medical reset. Is Ms. Kubisky represented by the Public Defender's Office? She does have 2 no bond holds on violation of
I
probation.
believe so, Judge.
So I'll find probable cause in absentia, and I'll leave the standard bonds in place. And she has no bond holds for violation of probation, and she has court on Monday with her division judge. Okay? All right. Tamara Moore.
She's a medical reset, Your Honor.
Your Honor, and I don't know if I don't know if I advised the court already. She was already referred to Judge Lerner Wren, mental
I
health.
think you said that.
Yeah,
And we were,
and I don't know, Brian, if you want to, at this point,
I'd like to see her get in front of Judge Lerner Wren as quickly as
all
possible,
right, so
to be
then,
honest.
do we need to sign a transfer order? Because you're saying she's already there, but.
I can't hurt to do it, I guess.
All right, well, let me do that. I'll find probable cause. She also has 2 no bond holds on felony matters. So we'll leave the $100 bond in place. And then I'll also sign an order to transfer to Judge Lerner Wren. Thank you.
Thank you, Judge.
All right, Keith Paisley. All right, Mr. Paisley, you have an out-of-county hold. This is out of Brevard County. And then you have also have an out-of-state hold out of the state of Georgia. So they both are no bond holds, and you should be going before the extradition court for the out-of-state matter next week, okay? All right,
Thank you.
okay. Carrie Charlton.
Judge, I've been informed the PD's services were declined.
All right, Mr. Charlton, you're before the court this morning for 1 charge of touch or strike, battery domestic, and number 2 is tampering in a misdemeanor proceeding.
Yes, ma'am.
Mr. Charlton, do you have private counsel?
No, ma'am.
All right, and are you planning on hiring an attorney? I guess that's.
Yes, ma'am.
Okay. All right, so you, at this point in time, you don't want the services of the public defenders?
I've never been in a situation like this. It's my first time ever being locked up.
Right.
And I would like to say something, please, Your Honor.
Well, let me tell you something. One, you can't
Yes,
talk
ma'am.
about the case because everything in this courtroom is being recorded and can be used against you. Okay?
Okay.
So this is why I'm saying, so you, if you've never been in the situation before, you have two options. You do have the right to counsel. The attorneys at the attorney who's at the main jail there with you is from the public defender's office. You may hire the public defender. You don't have to pay them right this minute. There will be a $50. Is it still $50? Application fee. And then you'll be able to speak with them, or you can proceed on your own and hire private counsel if that's what you choose to do. But you just need to know that you have those options.
Can I get some advice? Like, which one is better?
Only an attorney can give you the, well, I can't give you that, they're attorneys. So which attorney do you want to speak to is the question.
All right, I'll speak to a lawyer.
Well, the attorney's right there with you, Mr. Hill.
Oh, he's a lawyer, yes.
Yes, yes, he's a lawyer, so I'll give you a few moments to speak with him, okay? And then you can call me when you're ready. Alvin Carrero?
Yeah, but I'm not getting like.
All right. All right, Mr. Carrero?
Ma'am?
All right, you have two change of charge and one felony capias. So there's been a change of charge. Yeah,
May I approach, Your Honor?
sure.
Because the strangulation is an ad charge, so I thought you might want to see what the allegations are.
Aggravated battery with a deadly weapon.
The aggravated battery and criminal mischief are change of charges. Those are really more technicalities. The domestic violence battery by strangulation,
I don't have that.
it's not in the findings?
Nope.
Because that's, frankly, that's the only charge on the docket, I believe. Oh, my.
Yes, right.
And unfortunately, that shouldn't be the case either, because there still isn't a bond set on the aggravated battery and criminal mischief, so we really need to address that also.
So those have been handwritten in on my findings.
Okay, well, that's the
Number
start.
3 is the felony capias. Is the capias the strangulation?
That should be 5. Your Honor, if you have,
It says 5 felony capias,
yeah.
right? That's
On the booking, yes.
That's the strangulation, which is number 2 on the capias.
Yeah, it's 2 on the information, 5 on the charges that he's been booked on.
Okay, all right.
So anyways, Your Honor.
There's also a no bond hold on.
That is true also. On the aggravated battery, and it's really a lateral change, it was a change from bodily harm to deadly weapon. Bond was set at $25,000. On the criminal mischief, it was originally set at $1,000. I'm asking that the court keep those bonds in place. Now that you've been provided with the allegations, whatever bond the court deems appropriate on the strangulation, the state would be satisfied
Okay.
with.
But you're saying he has other no bond holds?
He has a felony VOP hold
Okay.
as well.
That's correct. I don't know if we have a date from
I'm
Mr.
sure- well,
Carrero.
His arrest was July 2nd, so I'm sure, I'm hoping you've seen his judge on that.
Have you been to court on your violation of probation, Mr. Carrero?
No, sir, I'm supposed to go on the 6th for a status on the violation of probation.
Let me-
Okay.
Next Tuesday.
That's all right.
No, I know, it's,
Thank you, ma'am.
All right, there's nothing the judge can do about the no bond hold this morning, right? You have to go in front of the judge who placed you on probation to deal with that.
Okay.
and yes, Brian, on July 8th, 2019, he had a first VOP hearing in front of Judge McCarthy and a denial was
Okay.
entered. And there was an order signed appointing the public defender.
Okay,
All right, so Mr. Carrera, I know we've said a lot of things today because we're just trying to make sure that we are all on the same page. All
Yes,
right?
ma'am.
So there are two charges which are lateral charges with, change of charges. So now instead of, aggravated battery causing bodily harm, it's now aggravated battery with a deadly weapon, all right? And then, criminal mischief, $200, under $1,000, now it's criminal mischief, $200 or less than, okay? So that's what those two are, and then the felony capious matter is the, domestic, battery by strangulation. So I find probable cause, I've been provided the affidavit, which I've read. I found probable cause. And, as to the strangulation, I am going to impose a $7,500 bond. $5,000 on the aggravated battery with a deadly weapon.
Your Honor?
Is that right?
No, that was originally set at 25,000.
That was. And the other one was 1,000?
The criminal mischief was
They're
1,000.
all like misplaced on, between the capious and the aggravated battery with a deadly weapon. Okay, that one's 25,000. That says number one, but I don't know if that makes sense. And then on the finding number 3, the criminal mischief. On the capious, it's number 4, that was 1,000. Is that correct?
I believe so, yes.
Were there any other,
There was no contact, but that's still part of the case. You don't have to reissue that, and
Okay.
that's it.
all right, and Mr. Carrera goes to court when?
Let me see.
The 6th,
No,
next
he's-
Tuesday?
Okay, sir.
That's on his VOP. He was arraigned by Judge Allspector yesterday on
Okay,
this case.
all right, good luck, sir.
Thank you, ma'am.
All right, Jaquez Dillard,
On to you. On to your honor.
all right, Mr. Dillard, you're before the court for an ad charge. This is a petty theft. And the court finds probable cause.
Yeah, he's got,
Judge, I'd ask you to leave the bond in place. He's got a no bond hold.
he's got an out-of-state hold.
This says no, charge number 20, he has a out-of-state hold?
Yes, ma'am.
All right, so I'll leave the standard bond in place. All right, good luck. Scott Deutsch.
He's approaching. Good morning, Your Honor.
Good morning, sir. You're before the court. You have a misdemeanor KPS. All right, this is a KPS that was issued September 24th, 2018. Does anybody know what this contempt, it's a contempt KPS? That was signed by Judge Lee?
Judge Lee, I think when people don't go to jury duty and stuff like that, I think he handles it's a specialized division, Your Honor, so I just ask that the court not take any action.
All right, so who does he go before?
He'll go before Judge Lee.
Okay. All right, sir, how soon can, Madam Clerk, do you know how soon we can get Mr. Deutsch before this judge? Okay. All right. They're gonna try and, you have to go see the judge, that it's a contempt order, so you're gonna have to go see the judge, okay?
Judge, Mr. Deutsch wanted me to let the court know, he is, in the process of receiving SSI benefits for a physical disability. In addition, he is a single parent. The mother is not in the picture. He is raising 2 twins at the age of 14 years of age. They are home by themselves. Is there a way the court would consider reducing that bond amount to something more reasonable, since this is a misdemeanor that seems kind of a little high? I don't know the facts.
Well,
as to why, but-
and neither do I. That's why I am not, I'm not inclined to touch it, because I don't know what the facts are. I don't know what the circumstances are. So, I've asked the clerk to see how fast she can get him before the judge, okay?
Thank you.
All right.
I get your approval to that communication.
All right, Lionel Beaumont?
I'm sorry, Judge, I'm sorry, one more thing on Mr. Deutsch, I did forget.
Yes.
If we can enter an order, he has not received, he takes high blood pressure medication twice a day. He's not received that as of yet, and he's getting very concerned about that. So if we can have an order to that effect?
Well, I think there needs to be a evaluation by the jail. I don't think I can,
He saw medical, but they haven't given him his medication yet.
because I don't think I can order the jail to give him any specific medication. I can sign an order to say that he needs to get his treatment. Yes. Okay. Okay. So do I need to write another order? I'm sorry? Okay, all right. Lionel Beaumont? All right,
Yes, ma'am.
Mr. Beaumont, you're before the court for a resisting officer without violence, and number 2 is a misdemeanor capias. All right, this is a capias that was issued July 15th. You did not show up for arraignment on a driving while license suspended charge. So the court finds probable cause? Yes, sir?
Your Honor,
Yes, sir.
I thought you said you dropped it the last time I came to court.
I did?
You said you dropped everything.
I don't
That's
know.
saying that
When did that happen?
I'll pull up.
when I seen the last time, you dropped everything. You said I have to pay nothing.
I'll pull up the case.
Yeah, please, thank you.
He's also on trial for possession of cocaine, case number 190075551 CF10A. And pretrial is asking that you revoke this pretrial. I'm trying to pull it up now to see if it's been filed, but my Odyssey isn't cooperating.
Okay.
Your Honor, it definitely wouldn't have been with you because when he was first arrested, he posted bond and didn't appear before you.
All right.
Then there was a capias, and he went before Judge Murphy, who ROR'd him, and maybe that's what he's referring to. And I don't know, and then he failed to appear again, and now he's back before you.
Oh, okay. All right, because I don't remember. Apparently, you did not appear before me. You appeared before Judge Murphy, who released you on your own recognizance. That's not dropping the charge. It just means that you didn't have to pay a bond to get out. And so now you're out, and then you miss court. So that's why the capias is there again.
Apologize.
Thank you, Judge.
All right. All right, so what does he want to do today?
Judge, I already had the chance to speak with him. With the bonds that are set, if the court was inclined to keep them there, that would be fine there'd be no argument from us.
All right, Mr. Beaumont, you need to make sure you go to court when you have to go to court. Otherwise, you're going to be before me or another first appearance judge. You've got to make sure that they have your correct address. What's your address?
630 Southwest 28 Terrace.
Okay. All right, so that's the address that they have. So you need to make sure you come back to court. I won't take any action on the pretrial.
Thank you, Judge.
All right.
Yes, you know.
Danielle Rose.
Approaching.
Judge Murphy. Easy
Well-
mistake to make.
All right, Mr. Rose, you're before the court for one charge of trespassing, and the court finds probable cause.
Judge, is the state attorney in a position to make an offer for Mr. Rose?
Sure, let me
Mr.
just,
Lindor, I'm sorry.
it's not a problem, let me just check one thing. If Mr. Rose wants to resolve the matter, it'd be a withholding court cost and no return.
All right, Mr. Hill, did you hear that? Withhold court
Sorry,
costs, no
sorry.
return? Withhold court costs, no return.
1 second, please.
Okay.
So, we've been, the three of us have been miscommunicating the past few days.
Yes, Judge, after speaking with Mr. Rose, he would like to accept that offer, please.
All right, Mr. Rose, please raise your right hand.
Okay.
Do you swear or affirm to tell the truth?
I swear and firmly tell the truth.
All right, put your hand down. Mr. Rose, do you understand everything that I've said to you today?
Yes, Your Honor.
And do you need any more time to speak with your attorney?
No, Your Honor.
Is anyone forcing you to resolve your case?
No, nobody's forcing me, Your Honor.
Are you under the influence of drugs or alcohol?
No, Your Honor, I'm completely sober.
And sir, do you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, Your Honor, I am 100% aware of that.
Have you ever been treated for mental or emotional illness?
Yes, Your Honor, I have.
And is there anything about that illness today that would prevent you from making a decision?
No, Your Honor.
And do you understand, sir, that you do have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, Your Honor, I am 100% aware of that.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, Your Honor, I'm aware of that.
What plea do you wish to enter, guilty or no contest?
No contest, Your Honor.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Was it a withhold on court costs?
Yes, ma'am.
And your sentence, sir, is a withhold adjudication and court costs. Good luck, sir.
Judge, on the disposition form, can we give Mr. Rose 90 days to pay court costs?
Wait and see.
Sure,
Thank you.
90 days to pay the court costs. How are you?
Fine, thank you. How you doing? Good morning. Happy Friday.
Who needs a Spanish interpreter? We had one before.
This whole weekend.
They called for the Spanish
Mr.
interpreter again?
Chinchilla,
It's Friday.
Mr. Chinchilla's here in the main jail.
it's page 25.
Thank you. Mr. Chinchilla? Are you Mr. Chinchilla? Please. He's approaching now.
All right. All right, Mr. Chinchilla, you are before the court today for one charge of grand theft,
Señor Chinchilla está ante el tribunal hoy por un cargo de hurto mayor
and number two is resisting officer without violence.
y el segundo es resistir a un oficial de policía sin violencia. Ah.
Do you understand, Mr. Chinchilla?
Señor Chinchilla, ¿usted entiende?
No, es que a mí me están acusando de algo que no hice yo.
No, they're accusing me of something that I didn't do.
Okay, well, you will have a time to have that heard before a judge, but it's not today.
Bueno, usted va a tener su oportunidad de ser escuchado ante un juez sobre eso, pero no va a ser hoy.
Today, we're talking about bond and release conditions.
Hoy estamos hablando de la fianza y las condiciones para su potencial libertad.
Mr. Chinchilla, are you working?
Señor Chinchilla, ¿usted está trabajando?
Sí.
Yes.
How much money do you make?
¿Cuánto dinero hace usted?
A la semana gano 700.
700 weekly.
Okay. Where do you work?
¿Dónde trabaja?
En Fort Lauderdale.
Fort Lauderdale.
What kind of business?
¿Qué tipo de negocio o empresa?
Painting.
I believe he said painting.
Okay. And where do you live, sir?
¿Dónde vive, señor?
En David Boulevard y 441.
I'm sorry, I hate it.
Davy Boulevard, I heard.
And 441, 441, 441.
Yes. Who do you live with?
¿Con quién vive usted?
Con mi familia.
With my family.
Who? Are you married?
¿Quién está casado?
No.
You have children?
¿Tiene hijos?
No.
Your Honor,
Uh-huh.
I can also advise the court, I do not believe his name is Venny Chinchilla.
También puedo informar al tribunal que no creo que su nombre sea Benny Chinchilla.
It makes reference to that in the report.
Hace referencia a eso en el informe policial.
But I would also note, if you look at the booking sheet,
Pero si ve a la hoja de fichaje,
and this stems from I'm not concerned about the prior.
y no estoy preocupado con respecto al antecedente,
It stems from a arrest on a traffic offense in 2003,
pero surge de un arresto por un incidente de tránsito del 2003,
where he was booked under the name Carlos Medina.
donde fue fichado bajo el nombre de Carlos Medina.
And the police report did say that they could not find anyone by the name of Vinny Chinchilla.
El informe policial sí informa de que no pudieron encontrar a ninguna persona bajo el nombre de Benny Chinchilla.
Ese es mi nombre.
That's my name.
The allegations are that he was taking paint.
Las alegaciones es que se estaban llevando pintura.
Ah,
He took several gallons of paint from the store.
Se llevó varios galones de pintura del negocio.
no fui yo.
It wasn't me.
And Judge, just so I could ask, I don't have the probable cause affidavit in front of me. A couple gallons of paint exceeded $300?
Simplemente para que pueda preguntar, no tengo el estado policial ante mí.
Well, specifically, it was
Unos galones de pintura.
a 5-gallon sealer, another 5-gallon of beer, granite grip tab, 2 5-gallon beer, granite grip gray. So it's another 5-gallon of wet look lacquer, another 5-gallon of sealer. So it's a total of $1,102.
And just,
And yes, paint is,
If the interpreter could interpret.
sorry.
Bueno, es un balde de 5 galones de sellador, un balde de 5 galones de gris para granito, otros 2 de gris para granito, otro balde de 5 galones, wet lacquer, y otro balde de 5 galones, que es un total de 1,102.
Ese reporte que hicieron los policías de Coral Spring no lo hicieron bien.
That police report,
Y es más, yo fui a devolver una pintura.
that the police from Coral Springs made is not correct, and even more, I went to return the
Do
paint.
not discuss the facts of your
No
case, sir.
hable sobre los hechos del caso, señor.
All right, let's do this.
Hagamos esto.
I'll leave the bond for charge 1 at $1,000.
Dejo la fianza de $1,000 para el primer cargo.
And no bond is required on 2.
Y no se requiere fianza para el segundo cargo.
All right, good luck, sir.
Suerte, señor.
All right, is there someone else who needs a Spanish interpreter?
¿Alguien más requiere servicio de intérprete en español?
Say it again.
Thank you.
You're welcome, sir.
De nada, señor.
All right. Mr. Sinise, it's good to see you. but
Likewise, Your Honor.
I can't promise
There's
anything is
121 just
possible.
for
We
that.
need you to come.
It's been that kind of week.
Yeah, it's not, it's
All right,
expensive.
Kenneth Lee.
What's that guy here for?
Approaching.
Why don't? Okay.
All right, Mr. Lee, you're before the court for a traffic KPS. It's operating with a suspended license, and you didn't appear for court on July 24th. So,
Yes,
the court finds probable cause. What does Mr. Lee wish to do today?
ma'am.
Yes, sir.
The only reason why I had a cape is
I wouldn't
because
admit to that. You're admitting guilt. Okay, if you don't have to listen to my advice, but I would not say anything about that, sir.
I just never got no notice in the mail.
He just wanted to indicate to the court that he didn't receive his notice in the mail, Judge.
All right, so what does he want to do today?
It was sent to
I
the
spoke
wrong
to him
address.
earlier today about the financial aspect. He's not able to post the bond that's currently set on the docket. He's requesting the court consider pretrial release.
Right?
Well,
No, I'm sorry, Judge. No, actually, take that back. My notes are confused. The complete opposite. If the court would be inclined to keep the $500 bond in place, that'd be acceptable to Mr. Lee.
Is it any way I can get
all right, well, the question is, where does Mr. Lee live?
3601 Monroe Street. Apartment 107. They ain't had the correct apartment number or whatever.
Well, this KPS was sent to 2214 Wiley Court.
Yeah, I know. That's what's on my ID.
So when are you gonna update the ID so that you don't have this problem? If you move, you need to change your address on your information. So to say that they mailed it to the wrong address, they didn't. They mailed it to the address that you have told the world this is where you live. Unless you change it and make it correct, no one will know where to send it to. So you need to stop. You need to change it with the clerk's office so that they have the correct address.
Yes, ma'am.
All right. What else are we talking? His bond is $500, okay? And I'll leave the bond at $500. All right, Alex, Dominic.
Thank you, Judge.
Okay. Do we have Alex Dominic?
Thank you, Judge.
All right, sir, you're before the court for disorderly intoxication. The court finds probable cause.
Thank you, Judge. Mr. Lindor, are you in a position to make an offer, please?
No, Your Honor, and as you can see the allegations, I don't know if there needs to be communication. There's a lot going on here. He has some substance abuse, some priors that would indicate substance abuse. I'm not necessarily insistent upon a monetary bond, Your Honor.
All right, I'll release Mr. Dominic to pretrial. There was some throwing of rocks and at the door and all kinds of things going on here. So I'll release him to pretrial supervision, standard, okay? All right, LaRon Wright. Mr. Wright bonded. Terry Jennings. Is that still a medical reset?
No problem, Your Honor.
Okay. All right, Mr. Jennings is before the court today for trespassing. And the court, I find probable cause. Mr. Jennings, what do you want to do today, sir?
I'm getting going with if I can go home, man.
Is Mr. Jennings before Judge Lerner Wren?
He was referred last time. The problem is his case pled out before the referral came through, so there was nothing that could be done about it. Your Honor, Mr. Jennings, I'm sure you remember Mr. Jennings. He's been through here a lot recently. He was arrested July 28th. He, on a trespass, he pled out. He was released the 31st. Then arrested the same day, July 16th. Got out July 27th, and then he was arrested on the 28th. June 30th, got out July 2nd, and then arrested on the 16th. April, so I think it wouldn't hurt to transfer the case to Judge Lerner Wren.
I think you should let me go. That's what I think.
Okay.
because I've been here, I've been sitting here, and I've done my time here for trespassing. Lauren Loren tried to see me yesterday, and I got into a fight just going to the court for her yesterday. So if he's going to speak for me, I'm going to speak for myself now. I don't need him to speak for me. No, I don't need him to speak for me.
Well, he really wasn't speaking for you. He was
Well,
speaking
I'm
on
just going to
behalf
tell
of the
him,
state.
let me speak for me. You're talking to me, and I'm talking to me. I'm talking for me.
Okay?
So if we're talking, I've been here for a while and I'm tired now. I want my son and my daughter, my twins' birthdays in a couple of days, and I want to go home to see them. I have a home in Fort Pierce where they are, and I want to be there for their birthday.
Well, I understand that, but for the last couple of weeks, every time you're released, 2 days later, you're back in custody. So,
Did you ask why?
well, I didn't ask why, but it's violating the law.
I'm right here before you right now. Ask why.
Well,
Because they sell drugs at the store and they only arrest me. They call the police on me so that I can leave because they want to sell drugs at the store.
right, but it's not your store, so you're
It's not.
you're not
It's not.
authorized to be there.
My kids come to the store. My kids come to the store. So I don't want my kids to go in the store with the drug dealers. So you're gonna tell me I have to let my kids go in the store with the drug dealers?
Well, you don't need to be at the store, and you don't need to let your
I won't
kids,
go to the
and
store.
you don't need to
I
let your
won't
kids go to that
store.
store.
And I won't let my kids go to that store. But I want to be out for my kid's birthday.
Well,
I've been in here, and you're gonna try. It sounds as though you're gonna try to hold me more. If I miss my kid's birthday, just tell me I'm gonna miss my kid's birthday, and Jennings just leave the courtroom. Say that.
well, the first thing I'm gonna tell you is that you probably need to check your attitude.
Yes,
You
ma'am.
you can say what you want to say in regards
Yes,
to
ma'am.
your case,
Yes, ma'am.
but you don't tell me
Yes,
what to
ma'am.
do.
Yes, ma'am, Miss Jackie Powell.
All right.
Yes, ma'am,
So,
Judge Jackie Powell.
Mr. Jennings, here's what I'm gonna do. I'm gonna leave your bond in place at this time, and I will sign that order to send your case over to Judge Lerner Rain, okay?
So
Yes.
I have to go back again.
Regarding the case for Scott Duke, they said we set it on Monday, 9:30 a.m. Judge Lee.
Okay. All right. All
Judge,
right.
I'm sorry to interrupt here, Judge. I think we heard over here in the main jail that on page 13, we called LaRon Wright, and I think I heard the word that he bonded. If that's true, that's actually not accurate. He's sitting in custody with us now. Page 13, LaRon Wright.
His bond has been posted.
Okay.
And Your Honor, I know I'm not trying to jump around, but.
All right, hold on.
Thank you.
Oh, wait a minute. Let me bring things back. Mr. Deutsch was here earlier on that contempt matter. What is it that you said, Madam Clerk? All right, so Mr. Deutsch will be before Judge Lee on Monday at 9:30? Okay. All right,
Great, thank you.
that's one thing. Yes,
Your Honor, we
Mr.
had
Lee.
thank you. We had put Carrie Charlton on recall for him to have an opportunity to speak to counsel.
Yes.
If we can recall it if they're ready. I just want to get my victim advocate out of here so she could do other things.
We're ready to proceed.
She has other things to do?
Yeah. Yeah.
All right, Carrie Charlton, what are we doing with Mr. Charlton?
Well, Your Honor, I'll advise the court. I see no history. I'd be requesting a $1,500 bond on one, a $500 bond on two, no victim contact.
All right, Mr. Charlton, who's gonna help you post your bond?
I have to call somebody.
Okay. Are you working?
I'm actually an artist, a musician.
Okay.
I'm not from here.
So you don't live here in Florida?
No, I don't, ma'am. I'm just visiting.
Okay. All right. I am gonna impose a $1,000 bond on count one and a $500 bond on count two. You have a total of $1,500 bond. No victim contact. Okay. All right, and sir, no victim contact means no phone calls, no text messaging, no social media, no third-party contact of the alleged victim in this case. Okay?
All right. Thank you, Judge.
Okay. All right, Anthony Kara. Thank you, Madam Clerk.
Cool. Thank you. I'll try.
All right, Mr. Kara is before the court. Charge 1 is burglary, occupied conveyance unarmed. 2, burglary, occupied conveyance unarmed. 3 and 4 are grand theft charges, and I find probable cause. Does Mr. Kara has a criminal history?
He does, Your Honor. And I'd ask that the court leave the bonds that Judge Roballo set in place. 2017, aggravated fleeing and eluding at a high rate of speed. 2017, grand theft auto, he was qualified as a habitual offender. 2017, grand theft, again, qualified as a habitual offender. 2014, criminal use of personal identification information and theft, a year and a day state prison as a habitual offender. Theft 2014, grand theft 2013 with a VOP. Grand theft auto 2011, 18-month state prison. Grand theft auto 2011, VOP, 18-month state prison. Burglary of a structure and grand theft 09, burglary of a structure 09, attempted burglary of a structure 07.
Okay. Mr. Hill, is there something you want to say?
Judge, yes, in regards to the monetary bond, Mr. Sierra was able to financially afford $1,000 on his end. As a result, would the court consider reducing counts 1 through 3 and set a $3,000 bond on each case? On each count, I'm sorry.
No, I'm gonna deny that. This time, I'm gonna leave the bonds in place. And,
Well, it says, I mean, he was booked for unoccupied.
It says occupied on the docket.
I'm just going by the booking and the warrants. Yeah, no, it says, if you look at the booking, it says charge burglary occupied conveyance under comments.
Yeah, I see the comments, but I
So-
also see the docket.
Yeah, the docket's just going by the charge, but if you look at the comments section on the booking sheet, Your Honor, it specifically says unoccupied, the warrant. And regardless of what it says anywhere there, Judge Roballo, it says unoccupied on the warrant that he signed.
no, I saw that.
Yeah.
I just want to make sure the court is
Yes,
aware that it
no, I
is
saw that.
unoccupied, not occupied.
I know. You know, once I'm in the mode, I read what's on the determination form. I do double check on the booking sheet, but I don't know why we can't, things can't line up.
It's modern technology at its worst.
Eric Ramsey,
Approaching.
all right, Mr. Ramsey, you're before the court on a felony capias that has a no bond hold and is not for magistrate, and you have court on Monday before your division judge. Number 2 is a traffic capias. It's a failure to appear in court. Is this drug court?
It says operating out of bounds.
And you do have a $100 bond on that, okay?
Yeah, count 1.
All right, so the court finds probable cause, and you'll see your judge on Monday.
Thank you, Judge.
All right, Everald Henry,
He's approaching.
all right, hold on just a moment. All right, we'll just hold on just a moment. Yes, confinement. Count 6 what? Yeah? Okay. All
On
right.
these type of charges, well, they
All right, Mr. Henry, you're before the court. Charge 1, false ID given to a law enforcement. Number 2, driving while license suspended, third or subsequent offense. Number 3, giving false information or reports to police. Number 4, disobeying or avoiding red light. Number 5, failure to provide insurance. Number 6 is a violation of felony probation, which has a no bond hold. You will go before your division judge on Monday regarding the violation of probation. The court does find probable cause as to the other counts. You have a $750 bond on 2. Then the other ones, no bonds are required or it's not for magistrate, okay?
Hopefully Monday do.
All right, good luck, sir.
Again, this is just traffic.
Dennis McCray?
See you Monday morning, okay?
What did we say about Mr. McCray? All right, Mr. McCray is before the court on charge 1 is burglary, unoccupied conveyance, unarmed. Number 2, grand theft. Number 3 is a court order. 3, 4, and 5 are court orders, no bond holds, and not for magistrate. And number 6 is an out-of-county felony hold. That's out of Palm Beach County, okay? The court does find probable cause.
Your Honor, I can advise you, the reason there's a $10,000 bond on 2, this case originated with an arrest warrant that was never executed.
Okay.
And then the state filed a not in custody information. I suspect that the bond got set at $10,000 on count 2, because that was what the bond was set originally on the arrest warrant. Why that didn't happen on count 1, I don't know, but bond was also set at $10,000 on that count on the warrant. I'd ask that the court set both bonds at $10,000 in light of the fact that he's got a pending grand theft in Broward, a pending burglary in Palm Beach County with no bond holds.
Oh, I see. They said hold for magistrate on that one. All right, 10,000 on 1, 10,000 on 2. The other ones are no bond holds. All right, good luck. Damien Pappy? All right, Mr. Pepe, you're before the court. Charge 1 is a misdemeanor capias. Number 2 is grand theft, and number 3 is possession of forged or altered bill. And the court finds probable cause. The capias is for a trespassing charge from 2016. You didn't show for arraignment.
Correct, Judge, and one of the things Mr. Poppy is confused about is he indicates he received no notice. Do we have something in the court file showing service?
No notice of what?
Of any court dates
Well,
to come and address this?
the felonies are not in
Never been
custody.
arrested for this stuff.
Mr. Hill, the felonies are not in custody. Capias, he would never have gotten court notice on the felony.
Okay.
And the misdemeanor is a
misdemeanor,
trespassing charge.
It says it was a no-show at arraignment.
Thank you.
Okay. All right, so, do we, want to talk about bond?
Judge, at this time, Mr. Poppy is unable to work. He's collecting disability, had a severe injury. He's not able to financially post a monetary bond. He is asking for pretrial release. However, he does live in Orlando. I don't know if that is possible to do so.
No, I'm gonna deny that. I'm gonna leave the bond in place. There are several different businesses that, The allegations are that Mr. Poppy wrote checks to himself from at least 3 or 4 businesses. So I'm gonna leave the bonds in place at this time.
That's 100%.
All right, Johnny Isidore.
Court date next week, okay? Hang on, okay, I know it's, you wanted to get up to that, I'm sorry.
Yeah, it's no big deal.
Okay.
Johnny Isidore.
Next person, y'all gotta move to the side.
All right, Mr. Isidore, you're before the court this morning. Charge 1 is lewd or lascivious conduct by a person 18 years or older, and number 2 is resisting with violence. The court does find probable cause, and I'll hear from the parties as to bond at this time.
Your Honor, I'm going to be requesting a $75,000 bond on count 1, a $1,500 bond on count 2. I would note his criminal history: a 2008 possession of cocaine,
2000 and when, I'm sorry?
2008 possession of cocaine, 2005 battery, 2005 resisting without violence under the name Canole Duberge, and 03 a DUI. My concern also is that statements were not only taken from the victim, but her sister as well. There's allegations of ongoing activity. The statement was taken from the mother that the victim reported it previously, and it was not reported. So I do have a concern. I'd also be requesting pretrial release with a GPS monitor, no victim contact, no contact with minors.
Okay.
Judge, at this time, in speaking with Mr. Isidore, he would be able to post a bond of around $1,000. Would the court consider reducing setting count 1 to be a $10,000 bond, along with pretrial release?
No, I'm gonna deny that. At this time, I am going to impose a $75,000 bond on count 1, a $1,500 on 2, no victim contact. That's also going to include level 2 pretrial, no victim contact, and no contact with the other witnesses.
Thank you.
Okay. James Smith.
No problem, Your Honor.
All right, Mr. Smith, you're before the court for possession of cocaine is number 1. And number 2, there's a violation of felony pretrial. That has a no bond hold and is not for magistrate. So I find probable cause, and as to count 1, your bond is $1,000, sir. All right? You'll have to go before your judge on the VOP. Good luck, sir. Ben Ali. Okay, is he in the room so we don't, is Ben Ali there?
He's approaching, yes, Judge.
All right. All right, so Mr. Ali is before the court on grand theft, uttering a false instrument, obtaining property under $2,000 by fraud. Court finds probable cause, and I've been advised that Mr. Ali's bond has been posted. Brett Connor. Mr. Connors before the court on 2 misdemeanor cases, and number 3 is robbery with a weapon, and the court finds probable cause. I'll hear from the parties as to bond.
One moment.
I was not a part of any robbery in 2019.
Judge, Mr. Connor's indicating that the robbery with weapon charge was already resolved.
Yes, it was resolved. Everything happened March. It was March 30th, 2018. That was when.
He says the incident date should be March 30th, 2018. He had an attorney, and they actually resolved that case according to Mr. Connor.
All right, I'll ask the state if they'll look at the.
Well, from what I can, I'm sorry, Your Honor, and that
This
is
has a
correct.
2019 case number?
Yes, that's when we filed it. It is correct that it allegedly occurred March 30th in 2018.
Right.
As far as whoever advised him that the matter was resolved, let me put it this way, it hasn't been resolved. This is the only,
When was the case filed?
this case was filed March 19th of this year.
Okay.
There is no, I pulled up Odyssey, I ran his name in Odyssey. There is no other robbery case in Odyssey other than this felony case, Your Honor.
Well, he mentioned the correct incident date.
Well, and Your Honor, I believe he is familiar with it because it does mention that law enforcement had contact with him
Right.
about the matter. And
All
then
right,
he-
so Mr. Connor, just so that you're clear, this case has not been resolved. The information was filed March of this year. And do we know if he has an arraignment date?
I'll check.
Ma'am?
Sir, just hold on and,
Yes.
Now that he has been arrested on the not in custody information and he's having his first appearance, I imagine the clerk's office will be scheduling an arraignment.
okay, all right, and your arraignment will be scheduled shortly, okay?
Ma'am,
Yes.
I was just, would like to say, right now, my girlfriend is pregnant and I have to work, and is there any way that I could, cause I could lose my job if I don't go to work right now, and I haven't had parents, my father killed himself when I was 15. My mom gave me up to the state, and I have no one right now, and I really need to take care of her. I turned myself in to yesterday because I'd gotten a call from a police officer saying that it wasn't resolved. So I told him he could come pick me up, and because
So why would you say when you come up before me, the first thing you said is this case has been resolved and there's no other case? Now you're saying.
I said I thought it was resolved.
No, you didn't. No, you didn't say that. You said it was resolved. So I don't know why why would you say that?
Because I thought it was resolved because that was what my lawyer had told
All right,
me.
Mr. Connor, I'm gonna tell you to stop talking, okay?
Yes, ma'am.
One moment.
He's got some misdemeanor matters.
Yeah, Your Honor, I would just note, really, I'm gonna be requesting a $10,000 bond on count 3. I would note the allegations. There apparently was a witness to this incident. The victim, who's a juvenile's mother, it appears there's evidence placing Mr. Connor at the scene. She was advised by her security company that Mr. Connor was at the location of their property, seeking to go into the property and specifically their residence. And note, yeah. But obviously, whatever Your Honor deems appropriate as far as release, I would be asking for no contact with, let's see, JR and,
All right, it seems like, even in the police reports, we have, conflicting information from Mr. Connor himself. So, Mr. Connor, what kind of work is it that you say that you do?
I'm a server at a restaurant, and I'm currently, I literally just saved up for my place, and me and my girlfriend moved in, and she's pregnant right now.
Judge, he's 20 years of age.
Yes,
Hold on.
Oh, sorry.
I don't believe, my argument to the court is I don't believe he's a flight risk at all. I mean, he did turn himself in once the police called him to do so. As a result of that, coupled with the fact that, he is a server, he is 20 years of age, he's not making that much money at this time. He does have a baby on the way he needs to financially support. Would the court consider reducing the bond somewhat to say $5,000 along with pretrial release and enable him to still work?
All right, I'll do that. $5,000 on count 3. That's gonna include a level 2 pretrial. Mr. Connor, if you don't, well, they're gonna have to come fit you for the ankle monitor, so. All right, good luck, sir.
Yes, ma'am.
Thank you.
Thank you.
Okay. Andrew Villardo.
Howard.
Mr. Villardo, you're before the court for burglary. Let me make sure, occupied dwelling unarmed. All right, the court finds probable cause. Does Mr. Villardo have any prior criminal history?
Pulling that right now, Your Honor.
Yes, ma'am. Which one? They want to do what now? He wants to come down? Judge Lee wants to come down in the PM? Okay.
Or the jail.
Yeah, that's the
We have to
key
let the
thing.
jail know.
Okay. I'm showing he has an open battery and assault out of Dade County. Battery 2015 out of Dade. Aggravated battery of a pregnant victim in 2000 out of Dade. A battery 2000 out of Osceola County. Resisting without violence and theft 2018 out of Broward. That's all I, one moment.
All right.
That's all I see, Your Honor. I do have a concern that this alleged burglary occurred when there was someone present inside the church.
Right, it seems like it was a church, Judge. It also appears that nothing was stolen.
Well, one could argue nothing was stolen because the victim was there and screamed, and he realized he wouldn't be able to enter and steal something without being seen. Also noting that he was, before this happened, he was witnessed checking employees' car door handles.
All right, so I'm gonna impose a $5,000 bond at this time,
That's for
okay?
no return.
And no return to this location, okay? Michael Keenan. All right, Mr. Keenan is before the court for a petty theft charge. Charge 1 is a petty theft. Number 2 is using anti-shoplifting control device. Oh, the court does find probable cause.
Thank you, Judge. Mr. Keenan is okay with the bond that's been set here on the document.
All right. He's got a $1,000 bond. Rafael Pabon.
No problem.
All right, sir, you are before the court for petty theft. Number 2 is a parole violation. Number 3 is grand theft auto. Number 4 is resisting officer without violence. Number 5 is a parole violation. Number 6, petty theft. Number 7, parole violation. The 3 parole violations, sir, are no bond holds. You should be going before the parole board. I find probable cause, and I'm going to leave all the standard bonds in place at this time, okay?
Okay, thank you.
All right. Romulus Hicks.
Just approaching.
All right, Mr. Hicks is before the court. Charge 1 is fraud, attempting to use ID of another person without consent. Number 2, resisting officer without violence. Number 3, unauthorized possession of blank or forged or stolen driver's license. Number 4 is the same thing, unauthorized possession of blank or stolen driver's license. 5 and 6, misdemeanor capias. 7 and 8 are felony capiases. Those are no bond hold and not for magistrate. The court does find probable cause. The bonds that are in place will remain. You have court next Monday and Tuesday for your felony and misdemeanor capiases respectively. All right, Jadarian Fox.
What's this? Oh,
Mr. Fox, you're before the court. Charge 1 is a violation of felony probation with a no bond hold. 2 and 3 are traffic capiases. Those have $250 and $50 bonds attached to them. The court does find probable cause. You have court before your felony judge on Monday at 8:30. Good luck, sir. Willie Lockett. Is Mr.
Judge,
Lockett?
he bonded.
Okay,
He bonded.
all right, Mr. Lockett bonded. Court finds probable cause. Kashan Gray.
He's approaching.
All right, Mr. Gray, you're before the court. Charge 1, loitering or prowling. 2, 3, and 4 are felony violation of probation. Those have no bond holds, not for magistrate. So you go before your felony judge on Monday at 8:30. A fine probable cause as to count 1, and the $25 bond will remain. Ryan Dunkins.
Thank you.
can I see your docket, please?
Mr. Dunkins, you're before the court. Charge 1 is loitering or prowling. 2 and 3 are felony violation of probation. Sir, those two and 3 have no bond holds. You go before your felony judge on Monday at 8:30. I find probable cause and the bond remains as to count 1.
Your Honor, just to go back to Mr. Paban for 1 second, I'm going to be
Paban.
asking for a photo order.
Okay, I'll sign that order. George Brenznock.
Approaching.
Okay. All right, Mr. Brenznock, you're before the court. Charge 1, burglary, unoccupied conveyance unarmed. Number 2, arson, first degree. Number 3, arson. Number 4, arson. Number 5, criminal mischief. Why do we have 3 arson?
Your Honor, if you look at the, I wasn't sure about that at first too. If you look at the last page, the first paragraph, I'm sorry, the second to last page.
Okay.
The sentence starting instead, the defendant exited the boat and fled the area.
Wait, the second to last page, what now?
It's technically the second to last page. The last page has no writing on it.
Right.
The first paragraph where it starts, the defendant said while he was
Oh,
removing the.
okay. Yeah.
If you look towards the middle, it says, within minutes, the boat was completely engulfed in fire and 2 surrounding recreational vehicles were damaged.
Totally missed
One
it.
entire, yeah, I didn't notice that at first either.
All right, so, find probable cause.
Your Honor, the state is gonna be requesting bond in the following amounts, $10,000 on count 1, $25,000 on 2, $5,000 on 3 and 4, GPS monitor, no victim contact. Mr. Brenznock has no criminal history. That being said, I am very concerned about these allegations, and I do believe the strength of the evidence against him is quite strong. Your Honor, there's witnesses that he made alleged threats to do exactly what he's accused of doing previous to this incident. There are witnesses placing him at the scene. He made admissions to damaging the boat. Now, he claims that he did not intentionally set the fire, but there is, it is mentioned that a detective with the Bureau of Fire, Arson, and Explosive Investigations went to the scene, based on the physical evidence, made a determination that Mr. Brenznock's claim that it was an electrical malfunction just didn't add up. and that appears that this was initiated by intentional acts to start the fire, damage the boat. My concern is, while fortunately this just resulted in property damage, boats, they have gasoline in them. This could have, if there was anyone in the area, could have caused significant harm. And there were people in the area because people witnessed in there. Two other individuals that have nothing to do with this matter had their property damaged, but based on Mr. Bresnock's actions. And I think anytime someone is setting fire to property, there has to be a great concern.
It seems like there is an indication that this is because of there's circumstances surrounding this is a divorce matter. The place where the boats were, is this where the wife lives, or is it just at a storage?
I could look that up. It sounds, the way it reads, it sounds like it was at a marina, but let me,
Okay.
or where there's deck space, but let me confirm.
Okay. All right, Mr. Hill, I'll hear from you in the meantime.
Thank you, Judge. I understand that the total amount of bonds is in excess of $45,000. Mr. Bresnock is not able to financially post that bond. He has been living in Florida for 22 years. He is gainfully employed at B&G Demolition. As you just heard state as well, Mr. Bresnock told me he's never been arrested in his life before. As a result of that, he can only afford between $500 and $1,000 on his own. Would the court consider, in lieu of monetary bond, pretrial release?
Based on these allegations, I would not be comfortable to just release him to pretrial supervision without a bond. There seems to be intentional, the allegation seems to be intentional.
And Your
Putting
Honor,
out the boat, taking things from the boat.
Your Honor, to answer your question, it does mention the alleged victim called her friend to go move the boat to a safe place. I don't, looking
Right,
here.
I was just thinking for bond purposes, if this was where she lives or
It
if
does
it was
not
a
appear,
separate
that does not appear to be the
location.
case.
Okay, all right, so, all right, so I'll impose a $10,000 bond on count 1 and 5,000 on 2, 3, and 4. Okay? No victim contact or no return to this location. He has no priors. I am not gonna impose a,
The only other request I would make, Your Honor,
yes.
and he needs to, based on the allegations, I would ask that the no contact order also include the victim's property.
All right, so Mr. Bresnock, is that how you say your name?
Bresnock, yes.
Bresnock, okay.
Yes, Your Honor.
No victim contact means no phone calls, no text messages, no social media, no third-party contact, okay?
Okay.
And no return to that location or wherever it is that your wife or ex, you're not yet divorced, right?
We weren't married, Your Honor. It
Oh,
was just
okay.
an ex-girlfriend.
All right, so no, so you cannot
We
go
were
to
just trying
where,
to split up our properties.
you cannot go to where she lives, okay?
Okay.
All right.
Yes, Your Honor.
Okay,
Thank you.
all right. Devin Hicks.
He's in court, 4750.
All right. Mr. Hicks is probably in court on his VOP matters.
Judge, I'm sorry, if we can go back on Mr. George Bresnock briefly. If we can enter an order allowing him access to his cell phone in order to call people in hopes of bonding him out? Would that
Sure.
be possible? Thank you.
Gregory Jacques.
Good afternoon, ma'am.
All right, Mr. Jacques, you may have been waiting a long time, but it's still morning.
Oh.
All right, so you are before the court today for a burglary, unoccupied dwelling unarmed. Number 2 is a criminal mischief, and number 3 is possession of cannabis, 20 grams or less, okay? The court does find probable cause.
Your Honor, the state would be requesting a $3,500 bond on count one, no return, no victim contact. Mr. Jocks had a burglary of an occupied dwelling in 2016, sentenced to 29 months state prison, theft 2017, failure to leave property 2016, trespass 2016, nothing further.
All right.
Judge, I'm going to ask the court to consider pretrial release for Mr. Jacques. He's a lifelong resident of South Florida. Unfortunately, he doesn't have any friends or family here in the area that can help him post his bond. He does not have any money himself to post the bond. So the only way that he can possibly get out is through pretrial release, and we would be agreeable to any special conditions that the court might think are appropriate. But he's just not going to be able to make a monetary bond.
Yeah, well, but it also appears that Mr. Jacques is homeless.
Yes, that's correct, Judge.
So unless
He has a shelter to go to.
Well, Honor,
not comfortable with that for the safety of the community, I'm gonna leave the bond. I'm gonna impose a $1,500 bond and no return to that location. Okay?
I'd ask the court to sign a phone order so Mr. Jacques can reach out to some friends in the hopes that they can come up with the money to get him out of jail.
All right. All right, Marquise Brinson, is he on medical loan? And Danny Sims?
Approaching.
All right, Mr. Sims, you're before the court, misdemeanor KPS, and number two is a violation of pretrial warrant with a no bond hold. So the court finds probable cause, and you'll go before your division judge shortly, okay?
Thank you.
All right, and just so, what was the name of that person? Mr. Deutsch, Deutsch, he was at the main jail, just so they know that he's been reset for the PM. Judge Lee will see him this afternoon so he can address his case, so we'll make sure he's available.
Yes, I was aware, thank you.
All right, thank you. All right, thank you, everyone. We'll see everyone this afternoon.